clearly we are seeing an increase in the usage of experts. 15 years back, I used to do 1 or 2 cases in a year. Today, I end up doing at least 15 to 20 cases in a year.
So, are you seeing increased use in arbitration proceeding and maybe litigation? Do you feel there's a shortage of experts in India right now?
15 years back, we had only 1 or 2 experts in the country. Today, we will have at least 10, 12 experts, and maybe more if we count some of the other technical experts as well. So, the field is clearly growing. And as we move towards a more friendlier, more simpler arbitration process, and even these mediations coming of age, we will see more and more usage of experts.
Hey everyone, welcome to another episode of On the Stand with Ashish Sharan. Today we have the privilege of speaking with a true heavyweight in the field of forensic finance and dispute resolution. Our guest today is Amit Bansal, a partner in the forensic and financial crime practice at Deloitte India LLP. With an impressive 29 plus years of experience, Amit has been at the forefront of some of the most complex commercial disputes, serving as an expert witness in domestic and international arbitration matters across forums like LCIA and SIAC. His expertise spans a vast range, from forensic investigations and antitrust matters to high-stakes credit assessments and PE investments. At Deloitte, Amit leads the dispute and litigation advisory services, where he has worked on over 90 commercial disputes, providing expert assessments and testimony on claim computations, forensic audits, and financial investigations. His work has played a pivotal role in cases involving shareholder conflicts, construction and logistics disputes, real estate controversies, and payment disagreements, many of which has influenced both dispute outcomes and settlements. So with such a wealth of experience, Amit brings not just technical expertise, but also deep strategic insight into what makes expert testimony persuasive and impactful. So when we thought of doing our first expert witness episode for India, I couldn't think of anyone better than him. So in today's conversation, we'll uncover the challenges, lessons, and behind-the-scenes stories from his career, shedding light on what it truly takes to be a successful expert witness in high-stakes litigation and arbitration. So without any delay, let's welcome Amit on the stand. Amit, welcome to the show.
Thanks, Ashish. Thank you so much. You really made me feel like a celebrity.
You pretty much are. So let's start from the origin of Amit Bansal, how your career began. You ended up into accounting, forensic accounting, and then the world of expert witness testimony.
Oh, well, that's a long story, Ashish. I have a career a little less than 30 years.
Mm-hmm.
Half of it is in the forensic space. And my entry into the forensic space was by accident.
Mm-hmm.
And to an extent, when I entered this forensic space, I did not even know that such a service area existed. And I was pretty circumspect and quite cynical about saying, hey, me and going into forensics, what is this? And the consultant kept on chasing me for almost a year before I agreed to meet. And after that, one thing led to another, and here I am, having spent a little more than half of my career in this space. So that's the story of my entry. Now, I obviously started with doing work on more on the forensic investigations and accounting matters and white collar crime related matters. And my previous half of the experience has largely been in the finance and financing space, financial modeling, hardcore consulting on projects, also on helping in fundraisers and stuff like that. Mm-hmm. And the expert role allowed me to use my forensic skill sets and my previous experience from the world of finance to be able to combine that. And that's the unique skill set which I bring to the table. Typically you will see people who are only, would have worked largely in one domain.
Yeah.
Whereas, I had the fortune of having worked in multiple areas and bringing together that experience, which helps me in my role as an expert.
No, I mean, like they say that, like the best magic happens when two fields cross each other. In fact, like there's this book I had read called The Medici Effect, where they talk about the Medici family of Florence as to how they brought in architects and artists and sculptures, and that led to the creation of the marvel that the city of Florence became. So, I mean, that makes perfect sense. The multi-dimensional experience is truly like coming together to, like help you in your career, your clients, your the lawyers who are working with you. So, as I understand, a lot of expert witness work in India happens primarily in arbitration disputes.
Yes,
Like litigation, experts are there, but not so much. So, before we go into the role of an expert witness in arbitration, can you tell us a little bit about the process of arbitration itself as it happens in India? And the Arbitration and Conciliation Act, and also maybe if you can touch upon the Mediation Act of 2023 a little, as to what kind of disputes you're seeing, what kind of issues are there that are prevalent in the country when it comes to these laws.
Arbitrations and or mediations, they're together known as ADR mechanisms, which is the alternate dispute resolution mechanism. And typically they have been provided to avoid litigations and to be able to facilitate a faster resolution of commercial disputes. Unlike civil matters, which continue for years together, commercial matters, if they continue for years together, it can have a catastrophic economic and financial impact on the parties as well as in the larger ecosystem. And that's the reason globally the ADR mechanism, both in the form of arbitrations and mediations, has been thought of to ensure faster resolution on commercial matters.
Mm-hmm.
Now, that's the genesis of why arbitrations and why mediations. In the Indian context, arbitrations have been there for a donkey's years,
Mm-hmm.
but it has been fairly ad hoc. If we look at, let's say, last 10-15 years and the period prior to that, the average time period of an arbitration prior to the last 10-15 years used to be upwards of 10 to 15 years. You can see an arbitration award in 10 to 15 years and sometimes even more, which is as good as what a litigation takes. Then what is the advantage which we are talking of?
Right.
And mediation was certainly unheard of. Now, in that context, if we look at it, in 1996, we had the new Indian Arbitration Act, which came up, which has been revised a few times in the last 10 years, which has led to tightening of the process and has brought us in par with international jurisdictions like Singapore and London in terms of processes and protocols. So now, one of the key changes which was brought in us in terms of timelines, it has been made mandatory under the Act for the tribunal give an award within a period of 12 months. A maximum extension of 6 months is that. So which is a very welcome change. Are we seeing arbitrations getting closed in this much period? Certainly not.
Mm-hmm.
If I look at it, I said that prior to the last 10 years, the arbitrations used to take anywhere between 10 to 15 years. But with these changes, what we are seeing in the last 5 to 7 years, the arbitrations are finishing in anywhere between 24 months to 48 months.
Okay.
Which is 2 to 4 years, which is a very, very welcome change over what it used to be 10 to 15 years back. So the pace has certainly become much more faster. This is also to do with how, the tribunals, the lawyers, the parties, it's a lot to do with the conduct of the other stakeholders also. And it's not necessarily, only tribunal that who has to ensure that the arbitration process gets done in 12 months. The onus lies on the parties and the lawyers, advising them equally. And, we find one of the parties always wanting to delay things, which is a typical thing which we see, in any litigation process, which tends to come even in the arbitration thing.
Okay. So you work all over the world. You've done arbitrations in SIAC and at the London Arbitration Center. So how do these centers compare to the whole concept of, like what's the seat of arbitration? And when parties are choosing the seat of arbitration to be India versus one of these centers, so where do you see the difference between the whole experience of a litigant when it comes to going through arbitration in India compared to one of these other international centers?
So I think the key difference between, let's say, India, Singapore, London, and we take these three as an example, is both Singapore and London have a very, very well-defined institutional arbitration mechanism, which till very recently was absent in India. Now, in India also, we are seeing an institutional mechanism coming up in the form of Mumbai Center for International Arbitrations, Hyderabad International Arbitration Center. There is one in Delhi which has come up. So we have seen institutional mechanism which has got set up. For any institutional mechanism to start getting used and get matured, it takes time, because the usage comes from when you are signing a contract today, and you are writing the arbitration clause, you will mention that the seat of arbitration will be India, and it will be used as per, let's say, MCIA rule or Hyderabad Center rules, which the legacy contracts do not have. All these institutions are new. They will see more arbitrations coming to them a few years down the line, when the contracts which are getting signed today, which will have such clauses, they enter into it.
Okay.
So, key difference is the institutional mechanism, which is come up in India recently, but it will take time for it to start getting used.
And what are some of the other hurdles that you as an expert have noticed when it comes to these proceedings, and which may be stopping India from becoming the arbitration hub, the dispute resolution hub that we so desperately want to be?
Well, I kind of said that a little simply in terms of an institutional mechanism. Let's delve a little deeper into what the institutional mechanism means in terms of an arbitration process and how it impacts the arbitration process. Now, we will compare it with, let's say, the ad hoc arbitration mechanism, which typically get used in the Indian arbitration context. We will not talk of the Indian institutional mechanism context, because that is still in its infancy, and there are very few arbitrations which have taken place in the Indian institutional mechanism as on date.
Okay.
Now, the key difference is, let's say SIAC or London, they have very, very well-defined procedural rule when it comes to arbitration process. And both the parties, they are actually bound by those procedural rules. Those procedural rules tend to cut down unnecessary delays. They prepare the parties well. They prepare the parties both in terms of expectations. And institutions like LCIA and Singapore, they also have a panel of arbitrators as well as experts. So they can make all those resources also available to the parties. And typically, especially the tribunal members, the arbitrators who are working with LCIA and SIAC, they are very, very experienced. They are very to the point, and they run an arbitration like an arbitration, an alternate dispute mechanism, and not like a litigation itself. As compared to this, in an Indian context, when it is an ad hoc arbitration being run by ex-High Court, Supreme Court judges, it turns out to be a court process outside of a court. It
Right.
literally runs like a litigation process and not like an arbitration process.
Mhm.
We are
Fair
seeing
enough.
those changes happening. Again, while I'm making a generic statement, we have some Indian arbitrators who are retired judges from either High Court and Supreme Court who actually can match any of the tribunal members from SIAC and LCIA. They really run arbitrations very well. So what it is doing is it is left to the choice of the arbitrators.
Mhm.
An institutional mechanism allows that they will select such arbitrators and keep only such people in the panel who understand the rules, who know how to run an arbitration process, and they run it like an alternate mechanism and not like a litigation process. So I like to talk about one personal experience.
Yeah,
I
sure.
have testified in LCIA, I have testified in ICC, I have testified in Singapore, uh, and I have testified in ad hoc Indian arbitrations. None of my cross-examinations in international matters have gone for more than 2 days. Maximum. And 2 days means total time of my cross-examination over 2 days could vary between 4 to 8 hours. Maximum. Typically a session is 2 hours. So we are talking of anywhere between 2 to 4 sessions. Actually 4 sessions, only one matter has gone into.
Okay.
Most of the others have got over in 1 or 2 sessions, which means 2 to 4 hours. Now let's talk about my experience in the Indian arbitration, ad hoc arbitrations. The shortest cross-examination has gone on for 6 to 8 hours, which means 2 to 4 sessions.
Yeah.
And the longest has gone on for 8 days.
Wow.
It is 16 sessions, 32 hours of cross-examination. And that was the matter which I thought would be the easiest matter. And there it went on for 32 hours. Something like this will never happen in an international arbitration.
Mm-hmm.
Arbitrator, the tribunal members will step in and they'll say, this is the maximum time allotted to you.
Yeah.
You have to finish. They will not let the counsel ask questions which are beyond the expertise of the expert,
Yeah.
or which are beyond the expert's report.
Yeah.
They are very well confined to experts' work,
Mhm.
to experts' expertise.
I think it's just a way that some lawyers would try and rattle the expert and make them a little uncomfortable. But then they also have the jury sitting on those trials there, at least. So, like the jury, and the jury members are lay people, so they may get affected by, okay, this person doesn't really look like an expert. But I don't see why somebody would want to use those tactics in arbitration, where it's in a closed setting and your arbitrator is not really going to be impressed by them questioning that you're throwing at the expert. But before I get a little deeper into the role of an expert witness in arbitration, I want to ask you a little bit about the notification that came from the government of India a few months ago, I believe, where they wanted to make a push for mediation over arbitration in government-related disputes. And from my limited understanding, the argument that the government tried to take was that a lot of times we'll go into arbitration, the award will come, then the award will get challenged again, and we'll again end up back in court. So let's try and avoid arbitration to some extent, and let's make a push for mediation in our government contracts. So do you have an opinion on that, and what do you think is going on here and why?
I think it's a very, very welcome move from the government
Mm-hmm.
in terms of showing the intent to go for mediation over arbitration. In a contract, you can't, at the time of signing the contract, especially when it's a long-term contract, you can't fathom every conceivable situation.
Yeah.
There are times when things change, when facts change, then you may need to alter the scope of work. The commercials may need to be changed. And we
That's
have
true.
seen a lot of public sector officials, well-meaning officials, they agreeing that the other side has a genuine case for extra payment, for extra time, for, some compensation. Let's say but we are unable to take that call ourselves because no one wants to be seen as having given benefit to a party. Now, they're not giving a benefit without reason. What has it done in the process? The government entity has incurred time and cost for running that arbitration process. And what they would have paid, let's say 100 rupees, they would end up paying 250 rupees because of the time value of money and the other costs incurred. So obviously government and government entities end up paying more because of this attitude. The officers keep on putting everything into arbitration rather than taking calls on it.
Yeah.
The intent to run some of these through mediation will help, one, in faster resolution, two, getting all those genuine cases resolved at the ground level itself, and not let unnecessary piling up of arbitration matters. So that is the good thing. Now,
yeah, no, that's a key insight. Sorry, go ahead.
so just last point from my side, is the intent or the notification good enough? I think government needs to create a mechanism both for their officers. The officers need to have clarity in terms of how to run that mediation process. What matters to get into mediation, and they should be aware, and without fear of anything, they should be in a position to put those matters into mediation. And the party concerned also needs to have that trust in the mechanism for this circular to actually see some traction on ground.
Yeah. So, because you followed the standard procedure, you are not taken a personal call, you are safe. But in the long term, you are getting hurt by just playing safe. And this is a very interesting insight that you have shared. So, thank you for that. Let me ask you now about appointment of experts. So, at what point during the arbitration dispute resolution life cycle are you usually brought in as an expert witness?
Okay. See, historically, if we look at the arbitration process, typically it starts with the application for the commencement of arbitration, appointment of tribunal. When the tribunal will have the initial hearing, they will do the framing of issues, and then the filing of statement of claims, statement of defense, rejoinders, all of that will happen. And then somewhere 6 months down the line from the start of the arbitration will comes the filing of evidence stage. Now, it is the filing of evidence stage typically most clients historically tend to come to us. Clients could be the direct corporates itself, or it could be law firm. We are seeing that changing where more clients and more lawyers are appointing us early into the arbitration stage. At the stage of filing statement of claim or statement of defense, as the case may be, because they want to get their facts right when they are, putting their statement of claims and statement of defense there. Because invariably what we have seen is when we get appointed at the evidence filing stage, the position of parties is already crystallized in the form of statement of claim and statement of defense. And then we go and we see some statements which are factually incorrect. And then we say we cannot take that into account while converting that into a number. And we take a different position. While the client and the lawyer will appreciate what position we are taking, but it creates issue for them itself because it's showing them that
Sure. Yeah.
their statement itself was incorrect.
Right.
So that thing gets corrected if we are bought in early on.
Mm-hmm. Yeah. And are the appointments always by only one party, or do you also see joint appointments or tribunal appointments as well?
Oh, well, there is an interesting development which is happening in that space. Again, historically, it has been only party appointed experts. One of the parties will appoint us, and we are a party appointed, we used to be party appointed expert. But over the last 3 or 4 years, we have seen all forms. When I say all forms, we have cases where one party has appointed us as their expert. We have cases where both parties have come together and appointed us as a joint expert. We have cases that we have been appointed as a joint expert through the order of the tribunal.
Mm-hmm.
Then we have cases where tribunal has appointed us as tribunal's expert and not as any of the party appointed expert. So we have all those kind of cases. Beyond this, we are also seeing a trend where we are getting appointed as joint experts or a party appointed expert outside of the arbitration process itself. You know, even before a matter reaches an arbitration litigation stage, at that stage itself, we are seeing clients appointing us because they want to settle. And it's in the spirit of trying to settle. They want to know where do they stand and hence at what amounts they should settle.
Mm-hmm.
So that's a welcome change.
And I keep hearing this term called hot tubbing of experts in the international arbitration scenario. So if you can just explain that concept a little, and is it the same as getting all the experts together for all the parties and then letting them, come with a joint report, or is it something else? Like, how does that work?
See, hot tubbing is typically a process where both the experts are put together and they are asked to come with a joint, what is known as a joint expert report.
Okay.
Outline their area of agreement, outline their area of disagreement, and then come up with a joint statement basis that. So what it does is it helps the tribunal's tasks so much simpler because they know that 20 points on which experts have commented. Out of those 20 points, on 10 points they have an agreement. On another 10 points there is a disagreement. So tribunal can focus only on those 10 points. Now the challenge in such hot tubbing is, in most of the time, 80% or 90% of the time, when there is hot tubbing, both set of experts have worked on different objectives and different data sets. You will hear that most of the times experts rarely agree. Now, how can the experts agree if they have had a look at different data sets and they have working towards different objectives? They will obviously disagree. Now, I think if there is a hot tubbing, they need to be brought to a common page, and only then hot tubbing needs to be done. Only then it will be success.
No, I completely agree. I mean, again, like the whole perspective changes. So this is something that we see in medical malpractice cases, again, in litigation, primarily in the US, where now they've started doing something called a blind review, where they will so the expert will be approached, but the expert will be given the medical records to determine if there is malpractice has happened or not happened. But they will not be told which party they are working for. So that then, like, at least for people on the plaintiff side, at least they now are getting a more neutral and unbiased opinion from the expert, because even that psychological bias, that, like, I should not use the word bias, but the change in perspective, it creeps in once okay, from what perspective am I looking at these documents? So I completely understand. This makes perfect sense. I have this one other question which I really want to ask you. You do cases on infrastructure issues, on real estate issues, energy, commercial contracts. And so how does the perspective changes when you're determining these damages? And how does your approach change depending on what sector you're working in? And what are some of the key challenges or key factors that you keep in mind, sector-specific aspects when you are working on a particular case?
Yeah. That's again, we'll have a long answer. I think I'll try and simplify the answer here.
Mm-hmm.
I think, see, the single most principle which is used for any damage competitor,
Mm-hmm.
irrespective of the sector, is that the injured party who has suffered the damage, that party needs to be brought to the same economic position as it would have been had the damage event not taken place.
Mm-hmm.
Now, that is the fundamental principle which every damage expert works on. And the methodology, any and every methodology is enshrined in this, is coming out of this principle.
Mm-hmm.
Now, one can say the methodology should be the same if that is the case. Largely, again, at a principle level, the methodology will be, because the damage event has happened, there is an actual financial position. Had the damage event not happened, we try and reconstruct what we call it as a but-for scenario. But for the damage event, this would have been the financial performance.
Mm-hmm.
So you try and forecast or reconstruct the but-for financial position. And the difference between the two, but-for and the actual, but-for minus actual, tends to be your damage. At a principal level, this is the approach in each and every matter. Now, the nuances of how a but-for scenario is reconstructed depends upon sector to which the matter pertains to and the sectoral nuance. In infrastructure contracts, say if it is a road project, the only variable which is unknown is the traffic.
Mm-hmm.
Rest, everything is enshrined in the contract. The toll rates are already there. At what rate of growth the tolls will increase, all of that is there. The financing model also actually exists. So it is relatively simple to compute damages because the only variable is traffic.
Mm-hmm.
Because traffic can change. You may have projected the growth at 8%. It may have actually grown at 10 or 7 or 6. So that tends to be the only variable. As against this, if it is logistics or if let's say it's a port company, a lot many more variables come into play. The model tends to become more complex. Well, a port will have different kinds of cargo. Each cargo will have different kinds of tariffs. Each tariff will have different kind of trajectory. And a whole lot of other port-related services also come into play. So, for that, if you have to reconstruct, the methodology tends to be a little more complex.
Mm-hmm.
The nuances come from the nuances of reconstruction comes from the nuances of the sector. That is what I was trying to come.
Fair enough. So I have, to be honest, I have a long list of questions. There are so many aspects I want to touch today, but unfortunately, we have limited time. So let me ask, I still have 3 questions that I definitely want to ask you. One, what advice do you have for the law firms and the parties who retain you as to what are some of the things that they can do better to allow you to guide them better and help them better? The one key takeaway was bring the experts sooner rather than later. But maybe one or two pointers that you may want to share with the lawyers or the litigants who may be listening to this as to how can they work with experts better? What should they do to make life easier for experts?
So one advice is to get us in early.
Yeah.
That will certainly help them. And that I have already said, and I can repeat that a number of times. That makes life simpler for everyone. Give the right advice to the client. But what we have seen is, there's a lot of passion, there is a lot of emotions which are there at the client end. And some of it also rubs on to the lawyers, the accountants. Okay, it is when you are running a process, it is important to be objective and less emotional and passionate about. One should know where we have a weak spot, and we should be willing to grant that position. And then see within our strong points, what is it that we can leverage and how we can strengthen our cases. I'll give you an example. In one of the matters where I was working with a client, and it was a matter where it was a shareholder dispute, where our client was the claimant and they had alleged breach of non-compete, and we had done the entire evidence gathering for that breach of non-compete. Now, in that case, the definition of business in the shareholder contract was a little vague. Now, the entity had some 7-8 businesses. And when we actually did, we figured out there were lots of businesses which were actually in violation of the non-compete clause. However, only there were 8 businesses which were in violation, but because the definition of business was quite vague, only 2 businesses could have been, 2 out of those 8 could have been clearly said because these are none. Other 6 was a legal issue in terms of, what view the tribunal will take. Now, our advice to the client was that, we only push for these 2, and we say these are 2 non-compete, it's a slam dunk. No tribunal can go against that. And it is like saying, and the remedy which was given in the shareholders agreement for any breach, whether you do 1 competing business or 10 competing businesses, the remedy is the same. So it's like saying, you do 1 murder, you do 10 murders, the punishment is the same. I said, your focus should be trying to get that remedy. But the client and the lawyers became so passionate. They said, no, we want to prove all 10 murders. Now, I said, okay, fine, but I as an expert can only say this much. I can't say what you want because this is not my domain. And ultimately, tribunal passed the judgment basis what our advice was to the client, which the client was not willing to adhere. So, we have to be objective. We need to see. And in the process, clients spent more money, more time, everything.
No, I agree. Passion can be a great thing, but not always. And you really have to assess and, make sure that you're always using it to your advantage. The other question I have is on behalf of the young, I wouldn't even call them experts, but the young professional who probably sees this interview or has heard of the whole concept of being an expert witness. And if you have to give them some advice on how they can start, in this field, if you had like a few pointers or some pieces of advice that you would want to give to somebody who is just starting out in accounting, then what would that be? Like a few like 1 or 2 things that accountants should do if they want to build a career in expert witnessing.
I think purely from a personal attribute or a personality attribute perspective, I think the key thing is to be able to remain calm, to be able to be objective, and to be able to withstand any amount of pressure. Okay, because you will come under intense pressure. You will come under intense scrutiny. That's the need of this job. The pressure can come from the client. The pressure can come from the arbitration process itself. The pressure can come from the intense scrutiny when you go through when there is cross-examination. I think being able to remain calm, being able to maintain your sanity in those situations is key. But if you are able to remain calm, you are able to think through. Second, keep things simple. It is very easy to make things complex. It's extremely difficult to keep complex things simple. So it's extremely important to keep things simple. The tribunal at the end of the day is a set of people with legal backgrounds. They will be lawyers, judges, and people, and less from commercial and technical background. You have to talk and explain things in a language which they will understand. If you explain things to them in a highly jargonistic and highly technical, it becomes very, very difficult for them to understand. And the tribunal also tends to lose interest. So simple message, keep it simple.
Yeah, that's always the best way to go about things in general as well. So my last question for you today, I mean, this is I have a long list of questions and I really hope, we can get you back some other time and go through those questions too. But where do you see the field going? I keep hearing from my friends who are practicing that, okay, we are seeing more and more use of expert witnesses. But where do you see I wouldn't call it an industry, but where do you see this, the use of expert witnesses going? And are you seeing increased use in arbitration proceeding and maybe litigation? And do you feel there's a shortage of experts in India right now?
So I think we are seeing an increase in the usage of experts. 15 years back, I used to do 1 or 2 cases in a year. Today, I end up doing at least 15 to 20 cases in a year. So we are clearly seeing increased usage of experts. 15 years back, we had only 1 or 2 experts in the country. Today, we will have at least 10, 12 experts in the country. And maybe more if we count some of the other technical experts as well.
Yeah.
So the field is clearly growing. And as we move towards, a more friendlier, more simpler arbitration process, and even these mediations coming of age, we will see more and more usage of experts. Time is not too far when we may see some of the experts acting as mediators, some of the experienced experts acting as mediators. At the end of the day, mediation is not a legal process, it's a commercial matter. It's a commercial disagreement. If you can show objectively to what it means for both sides, it becomes easier for the settlement. So clearly, I do see increase in usage of experts. I see more and more experts in different fields. Till now, we have seen experts largely in damages area, in construction space, and in valuation space. But I see emergence of experts a lot in the technology space. With more and more technology coming into place, with AI coming into place, we will see a lot of disputes coming in the tech space as well. So we will need experts from a technology perspective. That's one area where, again, neither the lawyers nor the tribunal members will understand. Somebody will need to decipher that technology and what it means for the tribunal members and the lawyers in much more simpler terms. Unfortunately, we have worked on a few tech disputes, both on IT infrastructure as well as on cloud services. So we are seeing emergence of disputes in that space, and that's an area where we will see more and more disputes coming up. So it's a growing field, like very, very specialized.
Oh yeah, that's for sure. That's why there are only experts allowed in the field. So, thank you so much, Amit. This was an absolute pleasure. There's so many new things I got to learn, and I cannot wait to do this again, bring you back on the show, talk about more aspects of being an expert witness. How can our listeners reach out to you if they want to see if you're available for a case, or if they want, like, for general advice? What's the best way to get in touch?
They can write me an email. They can call me up. You can give my number, both contact details to them. You can flash it at the end of this video.
Yeah, we'll put them in the show notes. Yeah, we'll put the contact information in the show notes, and you do have a LinkedIn presence as well. We'll put a link to your LinkedIn profile as well.
Yes.
And any last comments you'd want to make?
Well, guys, it is, while I may have sounded serious, yes, it is a fun space. You learn a lot of things while just seeing the actions of various people, various stakeholders. And I myself keep on learning in every matter. And one thing which this space allows you is to always remain a student, while you may still be called as an expert.
Yeah, well said. Very well said. So on that note, we'll take your leave. Thank you so much for your time today. It was an absolute pleasure.
Ashish. Thank you so much for hosting us. Thank you so much.
If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.